Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 22 of the DWI Guy podcast. Today, we are going to be talking about out-of-state convictions, out-of-state DWI convictions, or federal DWI convictions that result in a suspension of your client's North Carolina driver's license. I have seen a flurry of calls over the last several months coming from these type of suspensions. Somebody calls in, says, hey, I got a DWI in Ohio or New York or Washington 5 years ago, 2 years ago, and the DMV from North Carolina has just sent me a nastygram that says that my license is getting suspended. I need to drive. What the heck is going on? I did everything I needed to do in the other state where I was convicted, and now you're telling me that my North Carolina driver's license is getting suspended. So this is something that I, again, have seen a lot recently, but also have seen in the past, and it can be a real shock point for a client here in North Carolina because, again, there is a general time delay between conviction out of state and North Carolina getting wind of it, and then actually imposing a suspension here locally. So this is something that we want to get familiar with, something that we want to be ready for, prepared for, so that we'll be able to help a client that has this type of situation. So anytime that a client calls in with a DMV related issue, whether it's due to a DWI suspension out of state, whether it's due to a speeding ticket suspension out of state, whether it's related to something that happened here in North Carolina, anytime a client calls in with a North Carolina license issue, the first thing that I do is get a North Carolina driving history for that person. The driving history, the driving record from the North Carolina DMV, you can order it online, $8 for the non-certified copy. That is like the answer key for how to fix things, what needs to get addressed for a person to get their license back, or if you have to tell your client, sorry, you're SOL, can't help you, there's nothing I can do. And you know that firmly based on what you're seeing in the North Carolina driving record. So first thing to do is order a driving record. If it appears on the driving record that there is an out-of-state suspension, let's say John calls you, says, I got a DWI or DUI in Ohio 5 years ago. I was convicted. I had to do classes. I had to serve 2 days in jail, thought everything was behind me. And now I've got North Carolina telling me that they're suspending my license here because of this suspension from Ohio. Please help. If that is accurate, if North Carolina is issuing a suspension for an out-of-state conviction, the easiest thing to do in terms of helping that client get back on the road is that if they are eligible for a driving privilege for that out-of-state or federal conviction, that's the easiest thing to do. So generally you file that in the county in which the person lives. So if it's an out-of-state or a federal conviction, you file it in the county in which the person lives, the request for a limited driving privilege. And this is a civil filing. It's not a criminal filing. You don't go to criminal records. It is a civil filing. Basically, a lawsuit has to be filed. A civil file has to be opened in order to get the limited driving privilege process rolling. So you'll pay $150 civil filing fee. You will file that with a petition, basically a petition for a limited driving privilege, and that is AOC form AOC-CV-350. And effectively, that is the request. It is the asking for a limited driving privilege. Along with that form, you have to attach a driving history. So you've already had that because you looked at that to verify that there was, in fact, a revocation related to an out-of-state or federal conviction. And you have to have a DL-123 or the DL-123A attached to that limited driving privilege. The privilege is pretty straightforward. It is basically a one-page form. So there's not a whole lot of information, kind of just generic biological information about your client. And then beyond that, it's just kind of checking the appropriate boxes to say that we are requesting a hearing. And you have to give notice of a hearing to the district attorney, and then basically schedule it in front of the chief district court judge. Has to be scheduled in front of the chief district court judge of the district that you are in. So again, this is a civil filing. It gets filed in the civil clerk's office. You file the petition along with driving record and DL-123, schedule it for hearing. And depending on how often your clerk's office does this kind of thing, it may be very unfamiliar to the clerk's office, or it may be something that they see on a pretty routine or regular basis. But it is definitely within kind of the limited driving privilege realm, something that I see much less frequently. And so the clerks, again, may be a little bit unfamiliar with the process. Once you have actually requested the hearing and you're presenting the limited driving privilege to the judge, the chief district court judge, the privilege itself is relatively similar to a standard post-conviction limited driving privilege that would be issued here in North Carolina, the standard post-conviction privilege. So the backside of the actual privilege itself, and this is form AOC CV 352 for out-of-state and federal convictions. This form on the backside is basically identical to the post-conviction limited driving privileges that you would see on an in-state suspension resulting from a North Carolina DWI conviction. Basically the same thing. You're explaining in that petition that the driver's license has been revoked because of a similar conviction to North Carolina's impaired driving statutes from another state, that your driver would otherwise be eligible for a privilege and is otherwise eligible for license to drive. You have to verify that there's not any other revocations that are in effect. And then again, you have to attach the DL-123 form. Again, this has got to be presented to the chief district court judge. This form as well is still a civil filing form. So once it's signed by the judge, you would take it back to the civil clerk's office. The civil clerk's office will assign a file number to your case or to your filing. So you don't have to put in a file number. It's not like the citation number from out of state or the case number from the other state. The clerk's office, the civil clerk's office, will generate a file number for your petition for your case at the time that you file the petition to drive. And that's the same form that will be used, or the same file number that will be used on the actual limited driving privilege itself. So again, has to be presented to the chief district court judge In some counties, because of the size of the counties, the chief district court judge will specifically allow other judges to hear these type of privileges. So they'll have to kind of set that out, or that may just be common knowledge even in the clerk's office that other judges are allowed to hear this type of hearing, but the chief can assign other judges that responsibility as well. Once that is filed and you've gotten a file stamped copy of the limited driving privilege, then at that point, you are able to go ahead and send that to your client. And that is what is going to allow them to drive during the period of suspension resulting from North Carolina recognizing that out-of-state or federal conviction. Hope this was helpful, and I look forward to speaking with you again next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.